Rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in 3 cases this morning. First is 2079, James Construction Group against Westlake Chemical from Harris County and the 14th Court of Appeals District. Then 2273, Cadence Bank against Elizondo, also from Harris County and the 1st Court of Appeals District. And finally, 2802, Lake Jackson Medical Spa versus Gayton, again from Harris County and the 14th Court of Appeals District. The court has allotted 20 minutes for each side in each of the 3 cases, and we'll take a brief recess between the arguments, concluding them before lunch. The arguments are being webcast live this morning on the court's website and will be available later today in archives. We're ready to hear argument in 2079, James Construction against Westlake Chemical.
May it please the court, Mr. Goles will present argument for the petitioner, and the petitioner has reserved 4 minutes for rebuttal.
May it please the court. By all accounts, this is supposed to be a termination for default case. And in any termination for default case, this court is well aware there ought to be at least 2 notices in the record, right? You would expect to see a notice of default, and you would expect to see a notice of termination. But they're completely missing from the record in this case. And you might ask yourself, why is that? And the answer is actually very simple. This contract never was terminated for default. And we can look at the record itself to see exactly why this contract was never terminated for default. In our oral argument exhibits, we've submitted to you the first exhibit. It's an email sent from the contractor James to the owner Westlake less than a month after they claimed that this contract was terminated for default. It's at the bottom of the page, Defendant's Exhibit 862. This is in early May, again, less than a month after the supposed termination for default. This is us requesting release of the retainage on the mechanical portion of the job that they claim was terminated for default. About $2.7 million was being held in retainage, and we're asking that it be released. The next exhibit, Exhibit 2, is an email from the owner, internal emails amongst the owner, about a month after that. And here at the bottom you have Andrew Kenner, their senior vice president, asking the project director, Abram Quo, hey, I've got this invoice from the contractor James asking for a release of the retainage for about $2.4 million. These are his words, and he says nothing about the supposed termination. He says, do you agree that this is per the contract and do you approve this payment? What does Quo say? I'm okay with it. It followed the contract between the parties. Now remember, this contract allowed them to withhold payment and offset any amounts that were supposedly due to them for any supposed termination for default under this contract.
Was there also a provision that said that payment under the contract or payments made under the contract didn't waive any potential remedies or something like that?
Sure. And we're not arguing waiver on this point. We're simply illustrating to you there's no mention of the supposed termination for default or safety or anything at this time. And think about it common sense-wise. Would an owner who just terminated a contractor for default, who is about to sue that contractor for millions of dollars, willingly pay millions of dollars to that contractor? I mean, they turned around and they sued us about Christmas Eve of 2014, about a year and a half from then, for $20 million. It stands to reason that they're not going to willingly pay us $2.5 million if they actually genuinely thought at that time that they had just terminated that contract for default. We'd ask for you to turn to the next exhibit as well. This is about a year and a half later. It's shortly before they filed suit. This is October 30th of 2014. What this email is, it's a request for us to do more work on this very same job. Now again, remember their story at trial. at least 3 of their witnesses said, we killed somebody on the job, and they had to get us off the job as quickly as possible because we might kill somebody else. This is them asking us to do more work on the job. And bear in mind, we're still on the job through the late summer of 2013 performing civil work. So this contract never was terminated for default. What's interesting about this, the timing of this email, is it coincides with their trial counsel. If you look at their Plaintiff's Exhibit 219, at this very same time frame, it's when their trial counsel is attempting to identify, in what their words are, the best targets for litigation. So their trial counsel is developing one story, but we look at the project record and it says something very different.
So are you saying that lack of complying with safety rules, whatever, that results in an unsafe working environment does not constitute a default when it was specifically talked about in the contract?
There's a difference between a safety violation and a safety incident. And everyone who testified here, including, I believe, the replacement contractor, testified that the circumstances of this particular project lent itself to safety incidents. Because it's the nature of this kind of job. It's heavy industrial construction. When you have a compressed space and a compressed schedule, safety incidents are likely to happen. And these workers are human beings. So they're not robots. So safety incidents are bound to happen, but you can't necessarily equate a safety incident with a safety violation. And this is the problem with their story. Remember what the jury found. There were 3 submissions to the jury on these express conditions, right? one submission per condition. They were asked with respect to the first 2 whether there was strict compliance, they were asked whether there was substantial compliance, and they were asked whether it was futile to have complied with these conditions. The parties contracted for written notices. Written notices are definite and certain. This court recognized the significance of written notices in Berry versus McAdams. We've cited the case in our brief. It's a 1900 case. It has to do with a materialman's lien. And the statute in effect at that time required written notices to be provided to the owner. And in that case, the materialman stated that he had provided oral notice. And this court stated in Berry, the policy of the law is to relieve the owner from demands upon the ground of actual knowledge and constructive notice because he could rarely defend himself from such claims. Written notice is certain and definite information upon which the owner must act.
So why weren't the emails written notice?
The jury found that they weren't. Remember, with the strict compliance findings, the jury answered no with regard to the first 2 notices. And I think that, and those findings are unchallenged. They failed to find that there was written notice provided under this contract. And if you recall, too, there were summary judgments immediately prior to trial. The trial court actually found that the emails didn't constitute actual notice either. So I think what we're left with are these vague statements during meetings.
Actual notice? You said didn't constitute actual notice. I thought it was didn't constitute strict compliance.
The trial court found.
The jury found substantial compliance.
Right.
And would that mean that there was actual notice?
According to the jury findings, the elements that they were required to find did state, yes, actual notice. But I'm just calling attention to the fact that the trial court itself had found that the emails...
But the trial court can't make findings on summary judgment.
No, but that was his conclusion. I think what he was left with, I think, is what the argument ended up being at trial, too, is that it was these oral statements at these regular safety meetings that supposedly constituted these notices of default and failure to timely cure.
Let me ask you this. You have a claim for improper termination under Section 21.3. Under that claim, would you have to prove material breach in order to get a finding of breach of contract?
No, we argued the materiality on that in regards to the affirmative defense.
Well, but why wouldn't you have to prove that it's material in order to show that there was a breach? What I'm getting at is if you have to prove material breach,
right,
then why isn't the reverse of that substantial compliance?
Well, we would say that it's subsumed within these failures to comply with these particular conditions. We've cited in the briefing Bruner and O'Connor. This court is well aware of the significance. It's one of the most respected treatises on construction law, and it deals with these specific types of provisions, these termination for default provisions. And it states that because of the significance of what a termination for default is, in our oral argument exhibits, we included an excerpt from our damages expert, Brad Bright, who explains it's basically like a death penalty for the contractor, and when you terminate a contract for default, they have to disclose that on future bids, right? It's almost like they're
I
excluded.
understand the seriousness of the issue, but just as a matter of hornbook contract law, whatever kind of contract you've got, it has to be a material breach, right?
To excuse future further
Okay.
performance.
And so why isn't the flip side of that substantial compliance? And shouldn't that be the standard that we're looking at on the other side's claim?
No, I don't believe so, because I'm long-winded on the Brunner and O'Connor, but what it gets to is that courts routinely strictly construe and enforce termination for default provisions because of the significant and drastic remedy that it truly is. It's unilateral self-help by the owner. So that's why Brunner and O'Connor recognizes that even if there is a sufficient ground to terminate the contract for default, merely failing to take the contractually required steps, which is what we've argued, the failure in and of itself to provide the written notices in and of itself is a material breach of the contract, setting aside whether there was sufficient cause to terminate the contract for default. So we would say, I guess it's inaccurate to say we're not required to prove material breach, but because by proving that they didn't provide the written notices, that in and of itself is a material breach, at least according to the treatise and the cases cited within the treatise.
Do you agree with the respondent's argument that Section 17.2 is an independent basis to affirm, and under 17.2 there didn't need to be notice, or is
No, I don't agree with that at all.
So walk us through what the response is to that.
So if you look at the contract, Section 21, almost the title of it sums up our argument. That section is entitled Termination and Substitute Performance. That is the only provision of the contract, that section, that article, that deals with the subject of substitute performance. You would only be able to terminate, to end the contractual relationship and hire a replacement contractor if you comply with that section. So while you might have the right to intervene and stop work when you see an unsafe condition, you would not have the right to retain replacement contractors and hold James responsible for the costs unless you complied with that section. Otherwise, these provisions would have no, Section 21 would be rendered meaningless. Look at also Section 21.
I thought it did say something about that the owner could recover all costs associated with the intervention.
Right. If there were costs associated with the intervention, yes. But here we maintain, even if we say, number one, there weren't any costs incurred with the intervention, but even if they were, they waived them by failing to submit them to the jury. Remember, all of the damages they submitted to the jury were these termination costs, right? The cost to hire replacement or to safety train the replacement workers and the increased foreman costs, right? They narrowed down the number of foremen per workers. Those are strictly termination costs. Those aren't intervention damages. One of the ways to think about an intervention is if the owner, and notice too on Section 17.2, it's in Section 17 of the contract. 17.1 is entitled inspection, right? So the two work hand in hand. If the owner's out on the job walking the site and he sees an unsafe condition, right? He sees a hole in the ground that's not properly barricaded. The owner has the right, because the owner doesn't control us, has the right to stop the work and say, hey, you better fix that, you better put up barricades. And in that event, we're responsible for the extra costs associated with the barricades to put around it. But what it doesn't mean is they can't intervene by terminating, right? To the extent they want to terminate this deal and hold us liable for excess completion costs, they had to provide the 3 written notices required by the contract. And recall this, with respect to our strict compliance arguments, it's undisputed in this case. We're not arguing whether these are conditions or covenants. It's undisputed in these cases that these are express conditions. And it's undisputed in this case that not one of the 3 written notices ever was given. And remember the jury findings. The jury failed to find that the first 2 written notices were given. It was never asked whether the 3rd written notice was given because that was undisputed at trial, right? They rely on statements at the April 11th meeting, the oral statements. And it's also undisputed in this case that these written notice requirements never were waived and they're valid and enforceable. Now, this court is fully well aware of the significance of express conditions. Just last year, there were two separate opinions from this court on the significance of express conditions, and albeit in those cases, in Chalker Energy and Energy Transfer, this court upheld and enforced express conditions to contract formation. But in those cases, this court correctly recognized that virtually every court term, this court recognizes and enforces Texas's strong public policy in favor of the freedom of contract. And in the Energy Transfer case, this court cited MassTech, where this court recognized correctly that an indispensable partner to freedom of contract is contract enforcement. And that's all we're asking you to do. Unlike the owner, Westlake Chemical, we're not asking you to read terms into this agreement or out of the agreement. We just want you to take the express terms that these parties agreed to and enforce them as written. Now, ironically, the Court of Appeals in this case, in an earlier opinion, which we cited in our briefing and will be cited below, actually states the rule that we want this court to adopt on the strict compliance standard. This is the Emerald Forest opinion. And in that case, the 14th Court of Appeals stated, when a contract provides for a particular form of notice, compliance with such provisions is a condition precedent to invoking the contract rights which are conditioned upon the notice. And that's the rule we would like the court to adopt in this case. The parties freely agreed that 3 separate written notices were required. And in this case, it is undisputed that not one of those 3 written notices ever was given. You should hold the owner to its word and enforce the terms of this agreement. They neither had the right to terminate the contract for default, and they didn't have the right to recover excess completion costs from us. That ought to have been a summary judgment issue. And instead, here we are 8 years later, still arguing about whether or not notice was given. The Court of Appeals completely dismissed the significance of written notice, which again, I pointed out in Berry versus McAdams. This court noted the significance is to provide certain indefinite information to the recipient and not to leave alleged oral notices to somebody's memory that will fade over time and transform it effectively into a fact issue for a jury when it ought to have been a question of law for the court to decide. Had these written notices been provided, we would have them here today, where we could look at them and determine from the unambiguous terms whether the notice was actually given. And that's the problem with the substantial compliance argument. It is really incompatible with freedom of contract, the substantial compliance doctrine is. And remember this when they come up here to argue today. They're asking you to rescue them from the terms of their own negotiated agreement, right? This is a sophisticated owner on a $500 million construction project that couldn't be bothered to comply with the terms of its own agreement. And as this court noted in MassTech, it's not this court's role to protect parties from their own agreements, but to enforce contracts that parties enter into freely and voluntarily. And that's all we're asking you to do today, is enforce the terms of this party's agreement.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Harris will present argument for the respondent.
Mr. Chief Justice, and may it please the court. James spent much of its argument suggesting there was no termination because Westlake paid the retainage. Those were the same arguments that were presented to the jury, which rejected them. But I would like to get back to the first principles of Texas law. Substantial compliance has long been the law in Texas. This court has applied the substantial compliance doctrine to contractual requirements for over 100 years. At the time this contract was signed, all Texas courts that had addressed the issue had applied the substantial compliance doctrine to contractual notice provisions.
So let me ask you, so in answer to his last argument, and both of these parties are sophisticated parties, why shouldn't your client be held to the terms that he agreed to?
Because of the substantial compliance doctrine, Your Honor. Substantial compliance has long been the general rule in Texas. And again, every court that's considered the issue of whether the substantial compliance doctrine applies to a contractual notice provision, every court under Texas law, Texas courts as well as the Fifth Circuit and federal district courts, have held yes, it does apply. And there's a Fifth Circuit case that's on all fours. It's the South Texas Electrical Co-op case. And in that case, oral notice was given instead of the written notice specified in the contract. And the court held there that the substantial compliance doctrine applied. And again,
so it seems like the question is sort of substantial compliance with what? Maybe substantial compliance does apply, but you're saying substantial compliance with a notice requirement.
Yes.
And they might say substantial compliance with a written notice requirement. And if you look at it that way, and there's no written notice, then there's no substantial compliance. I mean, the assumption is that your assumption is that notice is all that matters, but should we just assume the parties don't care about the written notice, or that the written part of the notice isn't important even though they provided for it? I mean, how do we determine which piece of the agreement has to be complied with substantially?
It's substantial compliance with the notice provision required under the contract. Here it was a written notice provision. So we're looking at whether there was substantial compliance with that written notice provision. And the test is first, is there actual notice? Did they actually learn about it? And this is a high burden. This is a hard test to prove. You've got to show they actually got notice. Then you've got to show that the purpose of the provision was satisfied and there was no harm by the method in which notice was given. Again, that's a high hurdle.
So in that rubric, my question is, why isn't the purpose of this provision written notice?
The purpose of the provision is to give them notice in case they're required to do something. For example, the first notice under the contract was to give notice that there was a serious safety violation. That puts them on notice that there's a safety violation so they can fix it. That's the purpose of the notice. They got actual notice. The purpose was fulfilled, said the jury, and there was no harm in the method in which the notice was delivered, also said the jury.
If they had added a sentence or two that said, we really care about written notice, would this be a different case?
There's a very easy way to do that, and we do this in contracts all the time. The most common example is time is of the essence, where that's added. But if you'll look at tab C of the bench book that I provided, if James wanted a rule of strict compliance to apply, all that they had to do was to add that language into the contract, and that would contractually override the substantial compliance doctrine. And we provided examples of cases where parties have done exactly that. Written notice shall be provided and strict compliance is required. You wouldn't be talking about the substantial compliance doctrine. That is the law in Texas. Substantial compliance is the general rule. Substantial compliance applies unless the parties contractually say, we want strict compliance. And the cases we've cited in the bench book show exactly that. It would have been very easy for James to have done that. If written notice was the only way it wanted notice done, if that sheet of paper, as opposed to sitting down and having a meeting and walking through it, was the only way they wanted notice, that was available to them under Texas law. And again, that was the law at the time this contract was signed in May 2012.
Does that apply to every contract between every kind of party?
Substantial compliance, Your Honor?
Your substantial compliance with a written notice requirement theory would apply to every contract, and not just construction or sophisticated parties, but I'm thinking landlord-tenant. You know, a lease says if you want to renew your lease, you got to submit written notice no less than 30 days before your lease expires, or 60 days before your lease expires. And if we adopt that theory, that rule of law that you say is the law, and it applies to every contract, then aren't we just inviting a plethora of lawsuits saying, oh, but I walked into the leasing agent's office and said, I'm going to renew my lease. And now, and then the landlord says, well, that's not good enough. The lease says you've got to give us written notice. No written notice, we've already leased your apartment. And now it's going to be a dispute every time he said, she said.
2 points with that, Your Honor. In some areas like landlord-tenant, I believe there probably are statutory requirements about what has to be done. So sometimes I think the legislature may have spoken. But as to whether this is going to open the floodgates of litigation, substantial compliance has been the general rule in this state for over 100 years. We're not asking the court to change the law. That has been the law. Substantial compliance is the general rule. And when you look specifically at notice provisions, you look at the courts that have interpreted that. You have the cases three cases out of the Dallas Court of Appeals. You've got 2 cases out of the Fifth Circuit. You've got several federal district courts. You have a case out of the Eastland Court of Appeals. Every court that has considered the issue has held that it applies. James has cited no case under Texas law that says that substantial compliance does not apply to a contractual notice provision. So again, that is the law. This contract incorporated Texas law when it was signed in May 2012. That was Texas law at the time. It was also Texas law that if you didn't want to have the substantial compliance doctrine apply, it's real easy. You say, and strict compliance is required. Just like if you have a timing provision and you mean January 1, not January 2, you better say January 1 and time is of the essence. The parties have the ability to do that.
I just go back to, your assumption is that the business purpose of this provision is to provide notice.
Yes.
And as Justice Boyd was sort of alluding to, I mean, couldn't it be the case that the business purpose is to provide written notice, that there is some substantive importance or relevance to the written notice that gives the parties certainty and comfort about what's happened, and that is wrapped up in the business purpose of this kind of a provision?
If you look at the cases talking about notice provision, it's often the purpose of the notice is so that a party can take some action with the notice. And here, for example, again, the first notice is that there's a serious safety violation. The purpose of that is not to give them a sheet of paper. The purpose of that is so that they know Westlake, in its reasonable opinion, believes that there is a serious safety violation so that James can then take remedial action. And again, we go back.
And there are some emails about that, but is there any writing that confirms that the termination was because of serious safety violations? In other words, there's getting back to what Justice Blacklock is saying, is there anything in writing about the reason for the termination? And could everyone, after an oral meeting, decide we're all walking away and not understand from that there are potentially significant legal consequences from everybody walking away?
Your Honor, the notice that was required, the termination notice, is very simple. Under 21.3, it was only that Westlake is elected to terminate the mechanical work. It wasn't required to give a reason. The reason is the reason is in the first notice that there is a serious safety violation. The second notice is that Westlake is not satisfied with the quality and the pace at which James is attempting to cure that. And the third notice is Westlake is terminating a portion of the work. That's all that's required under that notice. And as far as the written requirement, had the parties after this meeting simply typed up a memo and put down everything that was said in the meeting and given it to James, that would have satisfied the writing requirement. But we are still here also arguing about the sufficiency of the notice. So even if there was a writing, James is complaining about the sufficiency of the notice, which is a different issue than whether there's a writing, and we're going to have litigation because there's no writing. But if this same meeting had been put down in a writing, they're still going to be arguing about what the sufficiency is. But the jury found that actual notice was given that satisfied Section 21.3. That was a fact issue. Whether the notice given by Westlake in this case satisfied Section 21.3, and the jury said yes, it did. There was actual notice, the purpose was fulfilled, and importantly, there was no harm to James. And those are the factors that courts look at in determining whether there is substantial compliance.
Does your position effectively write Section 9.1 out of the agreement? I mean, it doesn't mean anything anymore. It's just, it's not there at all under your theory.
It doesn't, Your Honor, because again, the substantial compliance doctrine applies. And substantial compliance is the legal equivalent of full compliance because the deviation is not material. Whenever there's actual notice, the purpose was fulfilled, and there's no harm. And that's the legal equivalent. And we've cited cases in TAP.
But then the point is, assuming those three elements are met, it is not necessary that any notice given pursuant to this contract shall be in writing. That just doesn't mean anything anymore.
If the high hurdle of substantial compliance is satisfied, then the written requirement of the notice is deemed to be not material, Your Honor. Justice Bland, you asked a question earlier about the retainage and Section 6.2, and I want to kind of come back to that. In closing, James argued that the retainage constituted a ratification. That's the way the retainage was argued in this case. And again, that was an issue for the jury, and it's in volume 19, pages 178 to 79. Importantly, the issue of retainage, and as you point out, Your Honor, section 6.2, payment is not evidence of performance or acceptance of work. So we know it's not relevant under the contract. The retainage issue doesn't go to the termination issue. What it goes to is question 3F in the jury charge, which is waiver, estoppel, or ratification. So this whole issue of retainage, in fact, is a waiver or ratification argument. That was submitted to the jury. The jury found against James, and James has not appealed those findings. So the retainage issue is not relevant to the termination issue in this case.
Agree with your opposing counsel that all of the damages submitted to the jury were termination costs and not intervention damages?
No, Your Honor. They were damages that were required because Westlake had to have someone come in and perform the rest of its work. And if you look at the damages required under intervention, it was the contract required James to reimburse Westlake for all costs associated with the intervention, which include costs by any third party. I mean, the cost provision in section 17.2 for the intervention is very broad, and the jury in this case found the same damages for the termination provision and the intervention provision, and that's why that is an alternative ground for affirmance. Unless there are any more questions on the substantial compliance or termination, I'd like to take a few minutes and talk about the counterclaim under the waiver of consequential damages provision. The Court of Appeals correctly concluded that James cannot recover on its counterclaim under the waiver of consequential damages provision. James's counterclaim depends on a determination that the waiver of consequential damages is in fact a covenant not to sue that gives rise to a breach of contract claim. The plain language in this contract shows that the parties intended this provision to be a waiver of consequential damages. The provision is entitled Waiver of Consequential Damages and establishes that the parties will not be liable to each other for consequential damages. The waiver provision is separated into two clauses. The first clause establishes that the parties waive liability for consequential damages, and the second clause precludes any argument that the waiver is ineffective because of the cause of action that's pleaded, and it also preserves claims for consequential damages if they arise out of gross negligence or willful misconduct. But James wants...
Under that theory, your theory that the second half of Section 26 really defines the scope of what is being waived, could you respond to the argument that that effectively reads out the middle kind of connecting phrase there, and no claim shall be made? What's your response to that?
It doesn't, Your Honor, because this clause is set up, it's really a compound sentence with two full pieces of it. And if you look up until from the neither company all the way through right before and no claim shall be made, that is what we're referring to as the first clause, and this is what the Court of Appeals found. And then it restates, and no claim shall be made by either the company or contractor, regardless of the nature of the claim. And what that does is defining the scope of the waiver. It doesn't write it out. And what James wants to do is to focus on that clause, no claim shall be made, that phrase in isolation, which of course this court shouldn't do. It should look at that in context of the entire provision. And nothing...
Isn't it another way to read it, though, and here's what I'm trying to get at. Couldn't you have accomplished what you say this provision accomplishes by just beginning with the word regardless immediately after the work and skipping and no claim shall be made? Wouldn't that accomplish what you say this does?
That would, I mean, it would in essence be rewriting. It would take it from, right now it's structured as a compound sentence where you really have two independent sentences, and it would take the first clause and have the second clause, the portion that's left of it, be modifying only that first part. So it would basically change the structure of the provision. But I think the more important thing in looking at the no claim shall be made, Your Honor, is what those words mean. Because there was a dissent in the Court of Appeals. And the dissent said that was a covenant not to sue, but I think we need to look at what that language is. And courts have interpreted no claim shall be made. Numerous courts have interpreted that in a waiver of consequential damages provision, and all of the courts have said that it bars the plaintiff from recovering consequential damages on a claim and does not address the issue of whether the plaintiff is prohibited from bringing a lawsuit in the first instance. Because to have a covenant not to sue, you need to have language saying that a party promises not to sue. If you look at the cases that James has relied on in this case, they all have that covenant not to sue language. They say things like covenant not to sue, covenant never to make the claim the basis of a suit, covenant neither to institute legal action. The focus of that is whether there is a covenant not to bring a suit, and that was the phrase that this court used in Westergren in deciding whether something was released or could be a covenant not to sue. It's that language promising not to sue, and all of the cases that James cites has that express language in it. That is what is missing here, and when you look at how the courts have interpreted, and we have set out several of the cases in tab F of our bench book, and I would like to draw the court's attention to the Fifth Circuit case in the Nisho-Iwa decision. There, the court determined that the language, no claim shall be made under any circumstances for indirect and consequential damage, barred the recovery of indirect and consequential damage. It didn't bar the filing of a lawsuit. And that is what is required under Westergren, is to have language that bars a party from bringing suit. And that is what is absent here. And if you look at the cases that we've cited in tab F, it bars the recovery. It bars recovery. It limits liability. It bars recovery. It precludes recovery. That has nothing to do with barring a party from bringing a suit. That clause simply doesn't say that, and no claim shall be made is used not infrequently in contracts. And so for this court to hold that a covenant not to sue is created by no claim shall be made would be changing the law, and especially here where this provision says nothing about not bringing suit. I would also like to point out that James has not cited any case in any jurisdiction that involves a covenant not to sue for consequential damages. And I think the reason for that should be plain, because parties often disagree about what does and doesn't constitute consequential damages. I mean, here, for example, we're 7 years into the litigation, still arguing about whether damages are or aren't constitutional damages. So James's position here that the parties intended to pioneer an unheard of legal device by creating a covenant not to sue for consequential damages and then burying it, taking one phrase and dropping it in the middle of a provision entitled Waiver of Consequential Damages, isn't reasonable and isn't supported by the contract language. Unless the court has any further questions, we pray that this court affirm the judgment of the Court of Appeals.
Any other questions? Thank you, Mr. Harris. Mr. Coates, I believe you have 4 minutes.
I'd like to correct a misstatement that opposing counsel stated. He said we never cited anything in our brief holding that strict compliance is the default rule. Pages 25 and 26 of our merits brief cite plenty of cases that the court can refer to. But in regards to his argument that the default is substantial compliance, Williston disagrees. He says in section 38.6 that when you agree to an express condition, the condition naturally means exact and full completion, meaning that the default is strict compliance. And if the parties want to agree for substantial compliance, they're free to. And here they didn't. And Justice Boyd, you correctly pointed out, if you accept their substantial compliance arguments, section 9.1 of the contract means nothing. Now here's the real problem with their substantial compliance arguments. They want vague statements at weekly safety meetings to supplant clear and unequivocal written notices.
What if they weren't vague? What if it was undisputed that your client received clear, unambiguous, direct oral notice of the 3 notices required?
The same contract terms, identical?
Saying, yeah, 9.1 is still there. You keep referring to vague, and there was an issue, but the jury found
Right.
otherwise. So let's assume very clear, direct, unambiguous. They gave you the notice required, it just wasn't in writing. You'd still be taking the same position, wouldn't you?
Yes.
Okay, so it doesn't matter if it's vague or not.
Right, but it should make a difference because these provisions are in here for a purpose, right? You know, the Court of Appeals is completely dismissive of this fact that this should be in writing. And this gets to the policy of these sorts of provisions, right? We want things to be clear and unequivocal. This should have been a question of law for the court, not a question of fact for a jury. If you allow substantial compliance in a case like this, you're going to have a fact question in every case. And you're probably going to have scenarios like this where you're going to be litigating whether or not an oral statement constituted notice almost a decade after the fact. You don't want to relegate these things to a swearing match between parties, between what was said and what was not said. And that's the real problem with the substantial compliance doctrine. I'd also like to point out...
Would you say that for strict compliance, it would have to say notice of a default at the top? Could it say something like removing the work may be necessary to prevent recurring incidents, and that would be, if that was in writing?
They were very careful at trial never to use the word terminate because their own witnesses admitted that word is nowhere in the record, right? They kept using the word remove. We would contend, as you correctly noted earlier, there are other provisions of the contract that allowed them to transfer work from us to another contractor. I would point you to sections 1.2 and 15.7 of the agreement, where we contend that that's exactly what happened. They took work, they either didn't assign further work to us, or they took work from us and gave it to the replacement, or the alleged replacement turner who was already doing other work on the job. We would contend that that wasn't notice of a termination for default, especially because the prior notices weren't given. Remember, he said we necessarily would have known by the time we received that last notice that it was a termination for default because of the prior ones, and we contend none of them were given.
So what would you say would have constituted notice? It would have had to have said default and the cause, terminate and the cause, or just terminate?
The contract required them, this is right out of 21.3, it requires them to specifically cite the breach, right? This has to be in the notice itself, so it has to tell you, and remember, it's not just an incident, it's a violation. This contract equates a default with a breach with a violation. So it has to tell you not that there's just an incident on the job, there's been a violation that needs to be addressed. And I'd like to point you to Oral Argument Exhibit 5. It's an excerpt of Scott Campbell's testimony. Scott Campbell is their technical manager on the job. He's the guy that supposedly delivered the statements at the April 11th meeting, right, where we were supposed to have been informed that we were terminated for default. He was asked, after we left the mechanical portion of the job and were merely performing the civil work, he was asked, apparently there were safety incidents that kept occurring with Turner, with MMR, and with Petrin. He was asked, you would have regular safety meetings with these folks. And I'd ask you to look at that testimony because he confirms what we said. You'd have regular meetings and no one thought that these were notices of default or termination at the time. So we would ask for you to reverse and render a take-nothing judgment on their claims, reverse as to our counterclaim and remand for further proceedings to the Court of Appeals. Thank you.
Any other questions? Thank you, Mr. Goetz. The case is submitted, and the court will take a brief recess.
All rise. All rise.
Please be seated. We'll hear argument in 2273, Cadence Bank against Elizondo.
May it please the court, Mr. Huttenbach will present argument for the petitioner. The petitioner has reserved 5 minutes for rebuttal.
Good morning. May it please the court. My name is Pat Huttenbach. I represent Cadence Bank. This is a UCC check case, and I believe the following question will be answered by this court. Is a bank customer who, ignoring many suspicious facts, ignoring many red flags, to earn a $10,000 non-refundable retainer for doing less than an hour's worth of work, who deposits a counterfeit check into their bank account, and then is that customer able to avoid the UCC and argue a common law cause of action to avoid liability? I think an important policy question for this court is, we have the Texas legislature who has enacted a specific code of laws over this exact area of the law, bank deposits and collections. And if under that law, the result is one thing, but then ultimately is an appellate court allowed to say, no, I can disregard that law, and instead I can focus on a common law cause of action? I think the court below erred for at least 4 reasons. The first reason is what I just talked about, the preemption. Does the UCC preempt such common law claims? The second is the court below erred because it created a conflict in Texas law. The American Dream Team case, under pretty analogous facts, said that the bank should win in that case, and the court below said that the customer wins in the case. That conflict has now created confusion for banks on how to handle such deposit issues.
But isn't there a difference here in when typically a bank would be entitled to a chargeback when there was a dishonored check, because there was a contract here between the lawyer, the customer, and the in other words, $55 was paid in exchange for the wire transfer. Doesn't that make a difference?
Not necessarily, Your Honor, and the reason I say that is because I think the court below, that's my 4th point, but I'm going to jump to it now because you asked the question. I think the court below erred in its contractual interpretation analysis. Paying $55 was an administrative fee. That's not consideration to have a credited check be irrevocable. In other words, you can no longer, if the check had been returned, let's say it had been an altered check, can that check be returned? If, let's say it was originally finally paid under Reg CC. Can that check then be returned if they find out it's an altered check, or it's missing an endorsement, or it has a forged endorsement? So there's a whole bunch of other issues. I don't think the intent of that quote contract, it was a wire transfer request form, was to irrevocably say that the customer can never be responsible for depositing a counterfeit check again.
So how much consideration would need to be paid for it to be a contract that would make a difference?
Again, because I'm not aware of banks that do that practice of guaranteeing a deposit, I think most banks would be very reluctant to enter into that type of contract because, as you pointed out, you would need a lot of consideration to be able to afford that risk shifting. The request form is just a request form. It was not a full agreement. The deposit agreement is an agreement. The purpose of the request form was to gather information. And so I think that, I can get to it a lot further on if you'd like, but I think the contractual analysis of finding this new contract that superseded everything. I mean, what happened to the underlying deposit agreement? Did all those terms just go away? And it gets back to the preemption issue. If this common law argument exists that the new contract was created, well, that any customer then can claim if they buy a cashier's check. and they sign a form. Does that throw away all the UCC? The UCC is clear who's liability, who is liable in this case. So I think that's my fourth argument, was the contractual interpretation analysis, I think, is misguided. There was not a meeting of the minds. The third one.
Does the UCC say, to your preemption argument in section 4.214, what in there to you says that the bank cannot waive its right to charge back the check?
When you say cannot waive its right to charge back.
Right. It sounds like what your argument is to me is that the bank cannot, by contract, waive its right to charge back the check. Is that your argument?
Well, the UCC, if you look at the UCC, what does it say?
It says the bank may revoke and charge back, which to me doesn't sound like, and then there's a provision further on that says the right to charge back is not affected by certain things, but none of those things apply in this case.
Correct. I think it goes to the underlying premise of the UCC. When you deposit a check into your bank account, you are making certain warranties when you deposit that check. You are warranting that you are entitled to enforce that instrument. You are warranting that all signatures on their instrument. So the whole purpose.
But the UCC doesn't make you rely on that warranty. It gives you a statutory right to charge back for a provisional credit. So it's giving you even more than the warranty. But what I'm asking is why can't the bank waive that right to charge back by contract?
I guess a bank could waive that right, but
Okay.
the UCC
So isn't
would.
that what we're about here in this case, is did the bank waive that right in the form that was filled out, which I understand you say is not a contract, but.
Well, before we get to the contract interpretation, to go to your question is, I think the UCC in comment 1.103 says that the UCC provisions they preempt common law claims. I mean, it says that in comment 2. And that.
Well, I understand that, but they only preempt to the extent that it's inconsistent with the common law, and we have a fairly high standard for preempting the common law. So what about, I guess that's the same question that I was asking you, is what in 4.214 is inconsistent with the bank's right to contractually waive its chargeback?
Well, if you go down that road, that a bank can alter the clear provisions of the UCC in a contract like that, what is the overall policy going to happen then? Because then any customer, to try to get out of the warranties that they've made under the UCC, is going to start claiming, just like in the American Dream Team case, the bank told me the funds were good. The bank told me the check had cleared. And in this case, the bank told me that the funds were collected.
But isn't that a problem if the bank does tell you that and that's not true? I mean, there are lots of other cases that have been cited in the briefs about where the bank did tell somebody that the funds are good, they've been collected, and that wasn't true. And in that case, the bank was not able to charge back.
It is a tough issue in American jurisprudence right now. But what I would say is that this court has said who is in the best position to try to prevent. This is from the American Airlines versus Martin case. This court said, and I quote, it says the UCC facilitates transactions benefiting both consumers and financial institutions by allocating responsibility among the parties according to who is best able to protect a loss. If the court ultimately rules that a bank can be liable in a case like this, banks are going to be extremely reluctant to provide provisional credits. So if it's an over $5,000 check, a bank might wait a long time. If a business deal has to get done, we're sorry. The Texas Supreme Court has told banks in Texas, be really careful about making provisionally credited funds available to customers. The problem with
But why couldn't they just be clear that it is a provisional credit?
Well, it's not just a provisional credit problem, because, again, that only gets us past the UCC midnight deadline and the Reg CC deadline. The other issue is that you'll know that within about a week. But these checks that are deposited in Texas, they can be a month later, a year later, up to 3 years later. If that's an altered check, or if that's a missing an endorsement or a forged endorsement, that check will come back. And how is a bank ever supposed to, if it's truly supposed to verify collected balance, how does a bank ever accomplish that?
Well, I don't know, but the CFR seems to suggest that collected balance means a payment for which, a check for which payment has actually been received. So the people who know better than me seem to suggest that it can be done. So That's where I'm a little bit confused.
And those provisions were changed in 2000 again to even make funds even more available, because the law wants banks to make funds available as quickly as possible. And so that's why those regulations have carve-outs for things like if it's in this case, if it was a new account or the bunch of overdrafts on the account, the bank might not be as willing to make funds available. So the funds availability is a big interest to Texas business. I think that the issue is there's a Reg CC issue on the final. The Reg CC says the check is finally collected if it's not returned unpaid by the midnight deadline of the UCC. But that only takes one part of the equation. The second part is if it's an altered check, you're not going to know that for months later, or if it's missing an endorsement. And so if you're trying to allocate who's responsible if this check is not a good check. Are you really going to know that in a couple days? In most cases, no, you're not. Most cases, it takes a long time.
And it seems like these rules cover the bank in that situation as long as you don't tell your customer that the funds are that the funds have actually been received.
And that's a good point. I mean, the UCC was changed in 1996 because right now, this is the law in Texas. The law says the bank can reverse that even if the customer has spent it. But the law changed the UCC. It used to be very strict liability or strict, interpretation up until 1996 when the Texas legislature said, you know what, we need to put some wiggle room into the statute. And so for the imposter rule, for the employee responsibility rule, for the repeat wrongdoer rule, they built in a good faith standard into the UCC that a bank, if you don't act in good faith, you could be liable. But this statutes that we're talking about don't have that good faith standard. It is if you deposit this check, you are warranting that this check is a good check. Period. That's what the UCC says. There's no good faith standard. The legislature could amend the UCC in Texas, as it did back in 1996, and build some of those things in and have some exceptions. But the UCC, this is the law that we have today. And the reason why it's rigid is because if you start getting into, well, is this really a contract? Is this possibly change the law? Then what are banks supposed to do with individual checks? And to get back to the earlier question about, is this really a contract? But then what does the bank have to do to, quote, verify a collected balance? Cadence truly believed, with this wire transfer request form, that the reason it thought it needed to verify a collected balance was to protect itself, not to protect the customer. If you write a $100,000 check and there's only $1,000 in the account, that bank is probably not going to pay that check or give you credit, allow a wire transfer to go out. But if you want to do I think I misspoke there, but if you want to do a $100,000 wire transfer and you have $200,000 in the account, the bank can say, oh, that you have enough funds in the account. But if you truly extrapolate that and say, well, collected means you've got to call another bank, who are you going to call? A teller over there? That bank's going to have to call their customer. Is this really a good check? I don't know. What if the check had been a legitimately issued cashier's check, fraudster copies the check? So it's not a good one. But if you call the bank's going to say, it's a good check. We issued that cashier's check. So legitimate person could be negotiating the check. And meanwhile, someone that's defrauded receives a check, they think it's good, you call the bank, it's a good check. You've got all sorts of problems. But the UCC, the way it's set up right now, has these rules that allow you to follow and you know your liability. So I think those are...
And I think that's the point, is if you follow them, you know your liability. But if you waive them or if you say something inconsistent with them, then the question is, can't you be liable in that circumstance?
The way that the American Dream Team Court handled it was we're going to throw away all these the breach of contract, all these other common law claims. If the bank defrauded the customer in your situation, if the bank really made evil, improper representations, but the American Dream Team Court said, look, the customer, there's no reliance here because the customer had been told in the deposit agreement that the provisions of it's a provisional credit. In this case, he was handed, when he deposited the check, 2 pieces of paper, a deposit receipt and a deposit slip saying, this is subject to the UCC. He was handed another slip saying that this is a provisional credit. And so
how about when the wire transfer form was sent to Mr. Elizondo, was it already completed by the bank employee to fill in the blank that said collected balance? Was it blank, or was that section already completed
It
such
was-
that Mr. Elizondo could have relied on it?
It was blank, and if you look at the document that he produced in this lawsuit, it's got a Cadence Bank Bates number on it. He didn't see it until the discovery of this lawsuit. So he could not have known what the bank had done with that. All those reps on that form, he didn't see it until well after the events had happened.
Does the record reveal whether Cadence Bank provides a mechanism for a customer to log in or get more detailed information of his own accord about whether credit is provisional or not? In other words, can the consumer, rather than rely on something the teller may say or not say, does the consumer have a mechanism, a statement, something to look at to determine whether there's risk associated with the deposit he thinks he made?
Justice, my time is
You may
up at all?
respond.
Okay. So to answer your question, there's a way to check an available balance with the bank. The problem with an available balance is there are all types of credits going in and out. You won't know that check is a good check that you deposit for up to 3 years. And you won't know it, your bank won't know it, the maker's bank might not know it, and their customer might not know it because they could get contacted 6 months or a year later that it's an altered check or something like that. So it would be very difficult to have a system of, are these truly collected, or as your question asks, funds? So.
Any other questions? Thank you, Mr. Huttenbach. We'll hear from the respondents.
May it please the court, Mr. Smith will present argument for the respondent.
May it please the court. Your Honors, Cadence Bank knew the very next day that these funds were not good, that the check was not valid, and that the funds had not been collected. We're not dealing with a 3-year situation here. This is the very next day. And I think there are 2 primary issues before the court. The first is, does it matter what this wire transfer request says? And second, what are the legal consequences? What does the form mean? Going to your questions, Justice Huddle, about the form as Mr. Elizondo saw it. But I'd like to start with the background rules of the UCC, of Regulation CC, the federal regulations, and of Cadence Bank's deposit agreement. We've heard a lot about how the sky is falling on the banking industry if we hold banks to their own contractual obligations. That simply is not the case. As we've shown in the bench exhibits, the UCC says time and time again that parties, including in banking relationships, may alter their obligations by agreement. Agreement is a defined term in the UCC. We aren't dealing with preemption in the least. To the contrary, Mr. Elizondo stands on the black letter of the UCC, on the black letter of the federal regulations, and on the black letter of the deposit agreement that Cadence Bank relies on.
But the opponent has argued that the $55 fee was not really an agreement to alter the contract. It was simply paying for administrative costs, which was a very small amount. What's your response to that?
2 responses. First, the document doesn't say that, and that runs contrary to centuries or century and a half of Texas case law. Merely a peppercorn can serve as consideration. And if we're going to argue about the rationality of the size of the consideration, that's not for the courts to second guess. Mr. Elizondo agreed to pay $55. That is undisputedly different from the consideration set forth in the deposit agreement. It's in the bench exhibits that we've provided. It's a $45 fee under the terms of the deposit agreement. But the deposit agreement also says repeatedly that we can set forth additional terms and additional disclosures governing the services that we may provide. And note the second page of tab D that we've provided to the court is a key example. It says that the agreement includes new or amended terms and disclosures we may provide concerning your account. It's not a violation of the deposit agreement or saying that the deposit agreement doesn't matter. To the contrary, Mr. Elizondo is standing on the deposit agreement, which told him to look for additional terms governing transactions like these in the documents that the bank provided to him.
If there had been $1 million in the account from other sources, and the bank received the wire transfer request from your client, is the bank in the same position as it is today? In other words, is your position that it didn't matter, it doesn't matter that there was plenty of funds to cover the transfer? By making any kind of a wire transfer, they then undertook the obligation to guarantee that all of the funds in the account were valid and couldn't be set aside due to fraud.
Right, I take the point, Your Honor, and I think that would be a slightly different issue because the text of the document says verified collected balance, not verify check number XYZ. But that's not what happened here. The bank's own document, the terms that it provided to Mr. Elizondo pursuant to the deposit agreement, which says look for terms on the documents that we provide to you regarding other services, they said that they would verify the collected balance. Turning back to the UCC, there's nothing that required Cadence Bank to immediately make the funds available to Mr. Elizondo. That's tab A of the bench book, UCC section 4.215. There was no obligation to make the funds available until Cadence Bank had received settlement from Chase. Federal regulations, regulation CC, there was no obligation to make the funds immediately available because this was a deposit of hundreds of thousands of dollars, over 90 times larger than the provision that Cadence Bank has cited dealing with making funds immediately available. That's for $5,250 or less. Nor does the deposit agreement require Cadence Bank to promptly make funds available. We've shown in tab C the parts of the deposit agreement that say the funds can wait. We can put a hold on the funds until we've received settlement.
But your position is that because they did not hold the funds, they became a guarantor of those funds, regardless of whether the check turned out to be counterfeit. And for how long did they become the guarantor? Say that the counterfeit discovery was confirmed a year later.
Well, I think that raises two questions. The first goes to if they made a promise, then it's what the promise says. And the second is we aren't saying that the door is open to risk shifting indefinitely for the whole 3 years. The UCC sets forth time provisions in which Chase Bank would have been required to make the funds available to Cadence. And if Chase had actually provided funds to Cadence, then at that point Cadence would have had funds that it would have collected. And whether or not Chase could have clawed those funds back 3 years later, that's not the facts of our case. It's like saying, well, I'm going to ask my babysitter to lock the front door to keep out the biggest, most egregious threats of burglars coming in, but that's not a guarantee that someone won't come in through the window. But if the babysitter doesn't lock the front door and someone comes through, I mean, you stop the most obvious threats where they are. And the most obvious threats are that a check might not immediately clear. And that's what this contract had to do with. It had to do with that initial period in which you're waiting on whether Chase Bank will provide the funds. It's not a guarantee as to whether or not Chase Bank might claw them back 3 years later under a warranty.
But it's also a promise that it won't claw them back?
No.
Within the provisional time?
It is a promise that it has verified the amount of funds that it has collected in Mr. Elizondo's account, as opposed to a promise about whether or not a third party, such as Chase Bank, might have some competing claim to that. That's a different issue. The issue is just, have they received the funds? And it's undisputed that they did not. And I think that goes directly to the risk shifting that Cadence Bank has argued. Only Cadence Bank is in the position to know immediately whether or not the funds have been collected. In fact, Cadence Bank said at the closing part of its argument that there's no way to know. You can look at the available balance, but that doesn't tell you whether or not the funds are provisionally credited or not. The only way for Mr. Elizondo to immediately know, the reasonable way for him to go about it, is to look at the documents that Cadence Bank has provided to him.
And to that point, was something provided to him showing what the collected balance was?
It did not say what the collected balance was at the time that he saw it. It did represent that the bank would certainly verify the collected balance before wiring the funds. And I direct the court's attention to tab G of our bench exhibits. And it's sort of blurry in the copies that we have, but in the middle, there's a statement that says, all blanks must be filled in. Mr. Elizondo was told that this is what the bank would do before completing the wire transfer. It's a black and white representation of all blanks must be filled in. There will be a verified collected balance. Down underneath the approving officer section, he is told that they will be sure to have verified the collected balance. And I think Cadence has raised...
The number was filled in after he signed it, right? And he never saw the filled-in number that just went into the bank's file?
That's correct, but it was represented to him that they were going to do that prior to the transfer. And I think this gets to the issue of what is a promise. Cadence Bank has suggested, well, this is just an internal directive that our own officers were supposed to fulfill. The document never says that. It has a signature up at the top for Mr. Elizondo agreeing to terms. He's agreeing to the amount of time the transaction may take. He's agreeing to paying tracer fees. He's agreeing to a new and distinct amount of consideration for the wire transfer. And beneath it, but above where he knows Cadence Bank is to sign, there are terms governing Cadence Bank's obligation. They include the duty to verify collected balance, to complete the form correctly, and then to go forward with the wire transfer. And I direct the court's attention to the City of Houston versus Williams case that this court decided about 10 years ago. It dealt with the definition of how do we know if something is just an internal directive to a department or if it's a promise and a representation to the parties. And the City of Houston case dealt with some city ordinances that dealt with benefits for firefighters. And the court said, because the ordinances used mandatory language, the firefighters shall be paid X or shall have certain benefits, that was mandatory representations that the parties were justified in relying on as a representation as the City of Houston's commitment. It didn't require magic words such as, I promise that, or I contract that. It's just a mandatory representation that the parties are justified in relying on. How much more so here where the bank provided the form specifically to Mr. Elizondo. It's given to him, unlike an ordinance sitting on the record book somewhere. And as another example, just looking at other contracts, consider arbitration agreements, which are in employment contracts all the time. And the rule is that if a party has notice of the arbitration policy and continues working, that constitutes an acceptance. And I point the court to its decision in Dallas Peterbilt from 2006, where a party just said, I acknowledge that I have received and carefully read or been given the opportunity to read the arbitration agreement. There wasn't the words of promise. The court didn't require the magic words of I promise or I commit that or I contract that. It's just enough to know the terms. That's exactly what we have here. There's a reason why they provided terms to Mr. Elizondo, and he had every right to rely on the bank's representation that it would do what it said.
They promised to put a number in the box, but I'm struggling with where they promised to not send the money if the number in the box wasn't enough, or to take on liability that the law otherwise wouldn't assign to them. The
whole point of contract construction, especially in the UCC, it's a very pragmatic, practical tool for evaluating the parties' responsibilities. And those boxes would be absolutely meaningless if it didn't require what it says, for the bank to be sure to sign off, be sure to verify the collected balance before making the transfer. What's the point of verifying a collected balance if it doesn't matter what it is? The promise is that they're going to go forward with this prior to transferring the funds. And the truth of the matter is that they did not. It's undisputed that they did not verify the funds that were actually collected in Mr. Elizondo's account. The phrase verified does not mean unverified. The word collected does not mean uncollected. But they went ahead with the transfer.
I mean, from the perspective of the customer, it seems the bank could have all kinds of reasons for wanting to put various things in various boxes on a form and giving directions to its employees. And I just don't know that. I don't know that it's reasonable to assume that there's an obvious purpose to this. I mean, the bank, you have this terminology and these different forms, and I mean, who knows what their internal purpose is for wanting to put things on this form.
The issue is not their subjective purpose in putting the words on the form or their subjective understanding of the words on the form. The issue is objectively, the test under City of Houston, it followed the restatement. The test for knowing whether a promise has been made is, quote, it's a manifestation of intention to act or refrain from acting in a specified way so made as to justify a promisee and understanding that a commitment has been made. And when the bank, without any disclaimer saying this isn't a contract, it doesn't even say this is for internal purposes only. The heading says who's supposed to fill it out. It's the center function to fill it out, but it doesn't say it's for center functions only. When they say this must be done in all capital letters, they say that these are the steps that you have to be sure to take before undergoing the transaction. And they provide it to Mr. Elizondo. That's a representation to him of what they're going to do, that he's entitled to treat as a promise.
How is that construction of the form, how does that dovetail with the provision in the UCC that says that transfer warranties cannot be disclaimed with respect to a check?
Those are two very different things. The transfer warranty and a disclaimer, it would inject uncertainty into the entire banking process if a customer could write on a check, I disclaim all warranties, and then deposit it and expect that the banks are going to treat the check as valid or that he can later disclaim responsibility for it. A unilateral disclaimer or even a contractual disclaimer is a far cry from an agreement that a bank makes about a subsequent and separate transaction involving a different risk, the risk that only the bank is in the position to know of whether or not the funds have actually been received into the bank's account. That's something.
Well, there was no argument here that the funds were improperly wired by the bank or they went to the improper destination, right? The whole crux of it is the check, and that the check was counterfeit. So to say that they're completely separate seems to be inconsistent with the idea that a warranty that the check is good cannot be disclaimed. And I'm trying to understand how that's separate when that was the cause of the harm in this case.
It's undisputed that there is a cause of action for breach of the transfer warranty. That's why the trial judge, Wesley Ward, that's why the Court of Appeals held that the bank has a cause of action for breach of that warranty. The issue is there a separate cause of action for the bank's conduct in a separate transaction? That's how it's wiring funds out of the account. And yes, the two are very closely related temporally. They're related to the same amount of funds, but they're separate transactions. They're governed by separate parts of the deposit agreement. They're governed by separate parts of the UCC. That they are viewed as separate and distinct transactions. This isn't a disclaimer where Mr. Elizondo says, oh, I'm not making warranties. This is an assumption of an obligation by the bank with respect to how it's going to perform this wire transfer.
If the agreement, if we treat the form as an agreement as you contend, why should we consider it clear enough to vary the bank's obligations under 4.214 when the Federal Reserve Board of Governors has said the term collected balance does not have a uniform meaning within the financial services industry?
That's a very outdated, it's over 20 years, maybe close to 30 years ago statement by the Federal Reserve Board of Governors. We've assembled in our brief many cases, many of them much more recent, setting forth the definition of a verified collected balance or a collected balance. And it's understood as the funds that the bank has received. And there is some room for disagreement in other situations, such as suppose that Chase Bank had credited funds to Cadence, but Chase Bank still, it was just a provisional credit. In that case, Cadence would have collected funds, but they would be provisional funds. Is that a verified collected balance? It's not entirely clear, and I think that's what the lack of certainty that the Board of Governors may have been referring to. But when it's undisputed that nothing has been collected at all, which is what happened here, that is a facial violation of the bank's obligations that it set forth in this document.
So we've all signed these forms before, you know, maybe it's the doctor's office or the DMV, or, you know, you fill out the top and we'll fill out the bottom. And it seems to me your position is, well, you the customer can look at the bottom that the other side's going to fill out and think to yourself, why do they want to fill this out this way? Like, what are they thinking here? And then you now have an agreement with them to do the thing that you think they're committing to do based on the way that their form is structured for their employee to fill out. Now is that the position?
Respectfully, Your Honor, no. We aren't saying that Mr. Elizondo was entitled to guess about the bank's purposes. We're saying that Mr. Elizondo was entitled to rely on what the bank said it would do. As for its purposes, that's subjective purposes.
So where did the bank say that it wouldn't send the money unless it had been collected?
It said that it would verify the collected balance. In other words, it's going to make sure that the funds are there before sending them overseas.
Well, but what if it verified that the collected balance was $20,000? There's some reason Chase flagged an issue and said, look, we'll credit $20,000 on this for now, but we're going to hold back the rest. And so this bank, Cadence, employee fills out the form and verifies a collected balance of $20,000. Now, would it, under your theory, have breached something in this form by then sending the wire transfer?
I think so.
So the question is, where on this form does it say we're not going to send the wire transfer unless there's enough of a collected balance?
There is first the rule that terms must be given meaning. If these terms mean nothing, then what's the point? The second is the UCC. This is a UCC agreement, and there attaches the duty of good faith and fair dealing, so honesty and fact. The bank is going to have to fill this out in a way that accords with its duties under the UCC. That's the point of the agreement.
Any other questions? Thank you, Mr. Smith. Mr. Huttenbach, I believe you have 5 minutes.
Thank you, Your Honor. My opposing counsel said that the way the UCC works is Chase Bank does not, he says, there are time periods for Chase Bank to make funds available to Cadence. Now, I give the UCC update speech to a lot of banking organizations. I was just president of the Southwest Association of Bank Counsel. I might be having a moment, but that is not my understanding of the UCC. When you deposit a check, your bank gives you that provisional credit. When you go through the banking system, you then send that check through the federal banking system. You get a credit into your bank account for that amount. If the bank is not timely returned, you keep the credit. It's not we'll give you a credit in a couple days. You get the credit immediately. That's not what the other opposing counsel just said. And that's why I think it was Justice Bland, I think you made the point of what happens if they return the check a year later? Because you get the credit originally. They might reverse the credit if they return it by the midnight deadline. But it could also happen, again, a week, a month, a year later, If it's an altered check or all the other hypotheticals, the other question you asked.
If we were, I'll give you another one.
Okay.
If we were to agree with you that the parties cannot make an agreement that's inconsistent with the UCC's provision that you can't disclaim the transfer warranties that are in the UCC with respect to checks. If we give you that much, why wouldn't there be a mitigation defense here? Sort of, okay, we're going to uphold the warranty, but what you did contributed to the loss.
I get that. I mean, I'm an attorney. I feel bad for Mr. Elizondo for getting duped. At the end of the day,
No, as a legal matter,
Okay.
Is there a mitigation defense with respect to your breach of warranty claim?
not the way the current UCC is currently written. I mean, in 1996, they made some comparative responsibility, or they made some good faith or mitigation type of things to several of these defenses that banks have, but that has not appeared yet in these transfer warranties or presentment warranties. It could be amended, but this is the law that we have today. The way the American Dream Team case got around is they carved out, we're going to throw out all the common law, but we're going to leave in a fraud claim, and they kind of created that new law. I don't really think that's the right mechanism either. I think the legislature needs to amend the UCC and say, look, we're going to build in a good faith standard or a mitigation standard if that's the way the law is going. The other question that you raised to opposing counsel was, well, if there was $1 million in the account, how are you going to verify collected funds? What is the procedure even to mitigate? Well, do you have to go back? Because if checks can be returned for up to 3 years under the UCC, that's 4.111 and 3.112, I believe. And so if checks can be returned, if they're altered, missing an endorsement, forged endorsement, you're going to have to look at that bank account balance of $1 million, look at every single check to make up that balance and say, is that truly, finally, irrevocably collected? For every single check, let's say there's 150 checks in the account making up that balance. How are you truly going to determine, are those really, finally, irrevocably collected funds? And the big policy issue that I think the court should consider is, what are we telling bank customers? Is it okay to deposit a check under suspicious facts? This attorney does not do this type of commercial collections, never handled an international transaction. No attorney was involved. It was $1 million transaction. He did, again, 1 hour of work and expected to earn a $10,000 non-refundable retainer. The settlement terms that he was told, the debtor in that underlying putative transaction or purported transaction said, I owe $903,000. His client was telling him, I'm owed $1,080,000. So if he had accepted this check, is he costing his client $177,000 because there's no signed settlement agreement? And he was getting all these emails. My daughter is in the hospital. Please send me the money. Please send me the money. And this court said in the American Airlines case, it said that the UCC facilitates transactions benefiting consumers and financial institutions by allocating responsibility among the parties according to his best able to prevent a loss. Do we want customers depositing checks under suspicious facts, hoping they clear, get the money out of the account, and then I get to keep it if the money's gone? I don't have to ever pay it back. No, we don't want to encourage consumers to do that. And the UCC has rules in place to protect that. Thus, we should reverse and render, or if there's a contract issue, reverse and remand.
Any other questions? Thank you, Mr. Huttenbach. The case is submitted, and the court will take another brief recess.
All rise.
Please be seated. We'll hear argument in 2802, Lake Jackson Medical Spa against Gayton. Justice Slarman cannot be present but expects to participate in the decision of the case.
May it please the court, Ms. McNair will present argument for the petitioner. The petitioner has reserved 5 minutes for rebuttal.
Good morning. May it please the court, opposing counsel. The Court of Appeals in this case failed to apply the 120-day expert report deadline set forth in the Texas Medical Liability Act. They ignored the fact that the plaintiff judicially admitted that her claim was a healthcare liability claim in the live pleading when the deadline expired. They then let the plaintiff recast her claim after the deadline and allowed her claim to proceed. While the court cited some of the applicable legal authority, it applied a lot of those holdings backwards. It switched the burdens. It never even mentions the presumption that applies when a plaintiff files a lawsuit against a doctor, his affiliate, and his employee for treatment that caused their injury. And the court ignores entirely Diversicare, which of course says, as we know, that a plaintiff cannot recast their claim to right around the act. I stood before this court in 2003 and argued Diversicare versus Rubio for Diversicare. We know that case has been cited umpteen times now for the proposition that a plaintiff cannot recast her claims to get around the act. We also know that case is cited for the proposition that if an expert witness is necessary to establish the plaintiff's claims, a healthcare liability claim has been alleged. But here we are 18 years later, and history has repeated itself, and we have another case before this court where the plaintiff has recast her claims to get out of the act in a case where it's clear that expert testimony is necessary to prove those claims. Just like in Diversicare, this court should reverse and the plaintiff's claim should be dismissed. In Rogers versus Bagley, Justice Huddle said that the act casts a wide net. This court has also held in Loaisiga and Bioderm that the act's applicability is expansive. We also know that the standard of review of whether a claim is a healthcare claim is de novo. So we have two problems in this case. One is procedural, one is substantive. Regarding procedure, the first question is, can a court consider a pleading that's filed after the 120-day expert report deadline? According to the act, the answer is no. If the live pleading on the 120th day judicially admits a healthcare claim, as this one did, doesn't the case have to be dismissed? And again, the answer to that question is yes. If a petition can be considered after the deadline, is a plaintiff allowed to recast their claim to get around the act? And of course, we've known since Diversicare and before, the answer to that question is no. But the Court of Appeals answered all those questions in favor of the plaintiff, and it failed to apply the law. We'll talk about that in a minute. Then as to substance, we have a case, whichever petition you look at, the plaintiff has sued a doctor, his affiliated medical facility, and his employee, alleging that treatments were performed on her that the doctor should have supervised and that she says harmed her. If we follow the rubric of the Texas Medical Liability Act, that claim is a healthcare liability claim, and it should have been dismissed.
Why isn't a claim in an admitted petition a different claim? So it's the claim that has to be dismissed if you miss the deadline. And why wouldn't we think of an admitted petition as stating a different claim?
Well, the issue here, I believe, Your Honor, is that because on the 120th day expert report deadline, which is not movable except for an agreement between the parties, which didn't exist here, she specifically and judicially admitted, I'm suing a doctor, I'm a patient, this is a medical negligence claim, they failed to abide by the proper standards applicable to all of these treatments that this doctor's facility provided to me. And our position is because she pled herself right into the act, that's the live pleading when the expert report deadline expired. Once the deadline expired, this new petition tried to rewrite around the act, and we say that petition was, one, too late, and two, prohibited by Diversicare. Does that answer your question?
Partially. I'm just, the statute directs the dismissal of the claim.
That's true.
And if the claim is no longer on the table because there's an amended petition, then it doesn't quite line up procedurally?
Well, I think that if she had filed an amended claim maybe before the deadline, we might be having this conversation. But as we say, since that deadline really should be the time at which we're determining whether or not a healthcare liability claim has been alleged, we say that it should be the deadline that applies. What we're concerned about is if we don't apply the deadline that's set forth in the Act, now we've got people once again ignoring that deadline. Now they're filing new petitions. They're trying to recast their claims, which we just know the law does not support. And actually, this case, the Court of Appeals opinion bears all of this out. The court recognizes in its opinion that the plaintiff alleged a negligent medical treatment, a negligent course of medical treatment, that she gave notice under the Act as required. There's specific provisions under the Act for giving notice before you sue a healthcare provider. The court recognized that she alleged she was owed a duty of care as a patient. So then the court recognizes that after we file our motion to dismiss, the plaintiff files this new petition and deletes all references to medical procedures and healthcare liability. Well, that's classic recast. The Court of Appeals should have recognized that at the get-go and just said, this case is dismissed. We know under Diversicare you can't do that. But instead what the court says is, the question is whether the second amended petition asserts a healthcare claim despite the removal of specific reference to the TMLA in the pleadings.
What if they amended their petition to state a claim that was obviously not a healthcare liability claim?
If she had changed her case entirely and pled, I drove up and I slipped and fell in the parking lot, then I agree with you that the face of that petition would not lend itself to all the presumptions required by the Act. Although, as we know, there have been cases where people have slipped and fallen and that's been a healthcare claim. If she had done something like that, the problem is that even with this new petition, setting aside when it was filed, setting aside when that petition was filed, if you look at the second amended petition, she's still alleging the same 9 acts of treatment that she alleges were performed on her that she alleged before. She says that there are breaches of the standards of dermatological care. She says that they improperly used lasers on her. We know this court knows that lasers are considered healthcare liability issues. She alleges the doctor failed to supervise the treatments that were performed upon her, and she alleges the applicable standards of care were not met.
So you don't have to automatically dismiss the whole case because you missed the deadline on the first claim. You do have to look to the amended petition to see whether it still states a healthcare liability claim, and then you dismiss if it does because they missed the deadline on the first claim.
Our position would be that the first claim, Your Honor, is out. All the pleadings everything that she alleged in that first amended petition, the live pleading on the deadline day is over, because it's mandatory under the Act that if no expert report has been filed, when your live pleading on the deadline day alleges health care, you shall be dismissed. That case is out. Now, if limitations hasn't expired and she can bring a claim because she slipped and fell in the parking lot, then that's a whole nother scenario, is what we would suggest. Because again, we're looking at if you apply the Texas Medical Liability Act the way it's written, you're looking at whether or not a healthcare liability claim has been alleged. And a healthcare liability claim is a cause of action against a healthcare provider or a medical doctor for treatment or lack of treatment or other claim departure from accepted standards of medical care or healthcare that proximately causes injury to the claimant. That is precisely what the plaintiff pled in her original petition, her first amended petition, and for that matter, her second amended petition. There is no dispute that Dr. Yarish, one of the defendants, is a medical doctor. There is no dispute that he owns and operates the medical spa. There is no dispute that Ms. Gutzman is his employee. If we run the Texas Medical...
But what about treatment? Are these treatments that somebody with a different type of license, like a beautician or a massage therapist or something else, are these treatments that can be provided outside the medical context by someone completely unsupervised by a medical doctor?
Well, the plaintiff alleges in this case that the doctor failed to supervise her, and she says that that's a cause of action. She voluntarily sought out this medical facility. It is a medical facility owned by a doctor to have these particular treatments performed. She talks repeatedly about the dermatological standard of care. We know dermatology is the practice of medicine. Also, there is nothing...
So are you saying that because this is a claim against a doctor, then it automatically concerns treatment?
No, I'm not saying automatically, because again, I know doctors have been sued because a non-patient slipped and fell or something along those lines, but she does allege she was a patient. Her pleadings, to suggest she was not a patient, her pleadings would belie any of that suggestion. Again, she says her medications should have been reviewed, her medical history should have been reviewed. We're not suggesting that simply because he's a doctor, any claim against him is a healthcare liability claim. But if we then apply all the rest of the definitions, you've also got his affiliate and his employee. So all three are healthcare providers covered by the Act. I had to do some of my own research because I was curious. But apparently skin pen is microneedling. Microdermabrasion has been defined by the Garza versus Sines case as a surgical procedure. Phototherapy is lasers. Again, this court has looked at lasers and recognizes that that's a healthcare issue. And then there's this VI peel, which apparently is a moderate depth chemical peel. The 14th court in 2018 had a case where a person alleged that a chemical peel burned them, and there was no dispute that was a healthcare liability claim. We have cited other cases in our briefing that show the court that issues related to these dermatological procedures are either undisputedly health care, or the courts have held that they are health care by running through the Medical Act rubric, which is, are these people health care providers? Has treatment been alleged? We also have a couple other things to talk about. The presumption. A presumption attaches when the plaintiff sues a healthcare provider alleging treatment injured them. That is what Ms. Gaitan alleged. So the presumption applied, which required her to rebut the presumption, which she did not do. The Court of Appeals kept switching the burden and putting it on us and suggesting that it was our responsibility to show we're not healthcare providers, even though we're defined the same under the Act, that this was not a healthcare liability claim. Those were not our burdens. Her petition pled her squarely into the Act and into that presumption.
Before you run out of time, can I just take you back? I just want to make sure I understand where you are on the deadline issue.
Yes.
Plaintiff files a healthcare liability claim.
Yes.
120 days runs. You file a motion to dismiss because there's no expert report. What if before the 120 days runs, she files a supplemental, not an amended, but a supplemental petition, slip and fall? Same case though, just two separate claims now. 120 days runs, you file a motion to dismiss the healthcare liability claim, but you can't file a motion to dismiss the slip and fall, right?
Depending on the circumstances, true.
The hypo you were giving,
in the parking lot, sure.
and all that, okay.
Yes.
But then what if instead she files the healthcare liability claim, 120 days runs, you file a motion to dismiss, and we know that claim shall be dismissed. You file a motion to dismiss, but before the hearing, she files a supplemental petition asserting the slip and fall. Now we get to the hearing. Are you saying the judge must dismiss the whole case, both of them? Or should the judge only dismiss the healthcare liability claim and then the later supplemented slip and fall can continue?
I would say my immediate reaction to that is that it's the healthcare liability claim that is governed by the Texas Medical Liability Act. So if it's a healthcare liability claim and the expert report was not served to support it, that shall be dismissed. Right. If there is some other part of the case, and we have to remember, as long as we're not claim splitting or any of those sorts of things, because we know we can't do that, if we really legitimately have something entirely separate and apart, then I think I would have to say that it sounds like the Medical Liability Act may not apply to that claim.
Right, and so in that hypothetical, the trial court should not dismiss the entire case. It should dismiss the healthcare liability claim, but allow the slip and fall to proceed, even though the slip and fall was only pleaded after you filed your motion to dismiss.
Well, because
Do you
the only
agree with
other
that?
deadline I could think of that would apply to the slip and fall would be a statute of limitations
Right,
then.
assume
Yeah.
all this happens before.
No, I think if I'm being intellectually honest with the court, I think that would be the way that it would apply. Now, if I drive home later and something hits
Right.
me, I'd love to
Well,
file
but if
something
we change
supplemental.
the hypo so it's no longer a supplemental petition, instead it's an amended petition that gets rid of the healthcare liability claim and replaces it with the slip and fall in the parking lot, seems to me the result should be the same. The trial court should not dismiss it because of the missed deadline, because the deadline doesn't apply to the slip and fall.
I think I would agree with that. The result is the same because now the healthcare liability claim is gone, and we know you're not allowed to just dismiss to make it go away.
And so
you can
why
get
in
around
this
it.
case is it a question of the deadline when really it's just a question of whether the amended claim is a healthcare liability claim? And I get all your arguments on that, but it doesn't seem like it's the deadline that you should be hanging your hat on here.
Well, the reason that we are focused on the deadline in this case is because we say that on that deadline, the plaintiff's petition, as we've said several times, did judicially admit a healthcare liability claim. I mean, she was dead to rights under the TMLA when that report deadline expired, and she was on notice. We filed 2 different pleas in abatement telling her to file her expert report, and she didn't do it. Instead, she added the medical doctor, and to my mind, made it worse for herself. We say that all of these claims, as pled by the plaintiff, are healthcare liability claims, that we don't have a slip and fall in the parking lot. These claims must be dismissed under the Medical Liability Act because the plaintiff did not file an expert report to support them. The presumption was in our favor. An expert testimony is required to support every claim that she has made. We believe that the Court of Appeals procedurally got this wrong and substantively got this wrong, and we're asking for a remand because we've pled attorney's fees as we're entitled to under the Act, and we've kept that claim alive throughout the proceeding.
Any other questions? Thank you, Ms. Vickner.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Armstrong will present argument for the respondent.
Good morning. May it please the court. Your Honors, over the course of many years and in several opinions, this court has been very clear in giving instructions to the lower courts about certain things that they should do to evaluate whether a healthcare liability claim exists. We believe that first the trial judge and in the 14th Court of Appeals followed this court's instructions to the letter and reached the right result. We say that because we know that this court has instructed the courts to, whenever you are presented with what on its surface may be a healthcare liability claim, to go beyond the pleadings and evaluating that and determine what the nature of the claim is and whether the nature of that claim is in fact a healthcare liability claim. You have instructed the lower courts to look at certain things. One of the things that has been crystal clear over the years is there must be a doctor-patient relationship. The trial court and the 14th Court of Appeals looked at the facts of this case and decided there was never a doctor-patient relationship. And that's really what the 14th Court of Appeals' decision turned on. I mean, that's evident throughout their opinion. And they didn't reach the issue. The second issue that you all have instructed courts to look at is whether there was actually medical care performed or some type of administrative function that is directly related to health care. The 14th never reached that issue in its opinion, but it could have. And if it had reached that decision, the result would still be the same. Because on the record before both courts and before this court, there is not a doctor-patient relationship, and there is no medical care that was performed. And if we start with the doctor,
treatment?
There was, but Your Honor, I think part of the problem that led to some of the drafting decisions in all of the petitions, and part of the confusion here even at the argument today, is treatment and the way it's used in this specific context. What Ms. Gayton did was she walked into a medical spa She met with an esthetician. The esthetician gave her an over-the-counter cream that she said was a treatment, the terminology treatment, and then she did some photo light therapy on her blemishes. There was no surgical procedure. There weren't the type of lasers involved in this situation as what has been involved in, say, the Bioderm case or some of the other what's called invasive lasers procedures that are involved in other cases where this court has found that there was a healthcare liability claim. And so what the court looked at, what both courts looked at to determine that there was no doctor-patient relationship was the fact that Ms. Gayton did not fill out any informed consent forms when she met with the esthetician. She didn't do any new patient sign-up sheets for Dr. Yarish. Dr. Yarish, importantly, didn't examine her. He never did a physical examination of her. He didn't diagnose her. He didn't give her a prognosis.
But is the crux of your allegation in the case that that was a failure, a departure from the standard of care, to fail to obtain a medical history, to fail to have doctor supervision over this employee? And how do you respond to their argument that your complaint is lack of medical supervision, so that has to mean it's a cause of action under the Healthcare Liability Act? How do you address that?
Well, Your Honor, again, we go back to the instruction of this court time and again to look past the pleadings to see what the actual nature of the claim is. Now, granted, we pled a dermatological standard of care or a medical standard of care that wasn't complied with, and then we tried to amend to get rid of some of the confusion about what the actual claim is. Our claim, the crux of our claim, and I think this is what the 14th saw, is the fact that he owns the property. There are things that are being engaged in on his property that were unsupervised, but they're not medical care. And as the owner of a facility where you have employees doing these non-medical things, you have certain just ordinary negligent standard duties to supervise your employees when they're doing that. And so I think what we see is it's akin to what this court has said before, and I'll quote it in one of the in the Loisaga case, where it says, "We fail to see how the legislature could have intended the requirement of an expert report to apply under circumstances where the conduct to which the plaintiff complains is wholly and conclusively inconsistent and thus separable from the rendition of," and they quote it, "medical care, health care, or safety or professional administrative services directly related to health care." And so by this court's instructions, there are instances where a physician can be held liable for activities that aren't health care related. And one of the things that is telling in reaching I don't know if the 14th considered this, but I submit that you all should consider this. In determining whether or not these treatments that my client underwent were health care, you can look at the Texas Department of Licensing and Regulations website. They have a frequently asked questions web page, because this area of medical spas is so confusing as to what's medical treatment and what's not. And so they have a frequently asked questions section, right? And we didn't see this at the time that we were drafting, or we wouldn't have made some of the petition drafting errors that we did. But it says clearly, estheticians are not medical practitioners. And the services that they provide are not the practice of medicine in Texas, right? And so it does say that there are instances where an esthetician who is licensed to perform laser surgery can be supervised by a physician, and they could perform that surgery. But if they're not licensed to use these very invasive lasers that were not at issue in this case, then it's not the practice of medicine. There also is a Texas Administrative Code, 193.172. And that states that in instances where a non-physician is performing services that are medical, whether they're non-surgical medical procedures or surgical medical procedures, that there are certain things that the law of the state of Texas requires that physician to do, which is all the things that weren't done in this instance. Do a physical examination of the patient, have informed consent forms, have medical histories conducted of the patient, generate written medical records, things of that nature. And so I think it would be a stretch to say that what my client underwent was medical care.
If it's not medical care, though, and if we agree with you on that, the statute also applies to health care and to treatment or lack of treatment, and each of those is separated by or. So don't we have to give those other terms, like treatment, a different meaning from medical care?
I think what the legislature, if you read that term in the context of this act, I think what the legislature intended to say was medical treatment, right, as opposed to skin treatments. And by way of example, the skin pins that my client had put on her face and on her back, I could go on Amazon.com right now and get that for like $200, right? Or I can buy a set of those things for a couple of $100. Those are not medical instruments that a medical professional would have to have. The lasers to contrast that, the lasers involved in cases where this court has said there was medical treatment involved, it involved treatments that were laser treatments for heavily regulated lasers that you only can obtain if you are a medical professional. I mean, does that make sense, Your Honor? Okay, and so I think when we look at everything in context and we look at the TMLA and we read the term treatment in context, I think the legislator intended it to apply only to medical treatment.
So I understand your argument, this is not a healthcare liability claim, but it seems that it's at least close to the line, it's at least debatable whether it is, and that being the case, why not just get an expert report to get that out of the way and take this argument off the table for them?
Well, because it was not required of us at the time. When we began to look very deeply at what these treatments were, our understanding shifted that these were not medical treatments, right? And so what we would then have done is complied with a requirement of the statute, expended money to get an expert in a situation where that wasn't necessary. And this court has always instructed courts that if there is not a healthcare liability claim, you don't have to get an expert report. I mean, this is where these fights are usually had, at the point where do we need an expert report?
Would you need an expert at trial?
I would submit that we do not, right? So the two products that were used in combination that we are complaining about are both over-the-counter products. Estheticians are trained on how to use these over-the-counter products. I would venture, and I'm not sure because we've never gotten to this point, but I would venture to guess that if we looked at product warnings and labels for these two products, they would probably say, don't use these two things in combination. And an esthetician would be able to tell us, hey, when I was being trained, I learned not to use these two things in combination.
Isn't that an expert qualified by experience?
But I think and I understand what the point you're raising, Your Honor, is that you would need an expert. The cases that have said, if you need an expert, it's a healthcare liability claim. But I would ask the court, then what does that say for instances where medical treatment is involved? Does that preclude you from bringing an expert that's another esthetician or another med spa business owner that says, yeah, we never allow our people to use those two things in context? They would be an expert, but they're not a medical expert, right? And so I think the court's prior cases that have said, if you need an expert, it's a healthcare liability claim. Again, I think that is in the context of if you need a medical expert, it is a HCLC. If I may just wanted to, if there are no other questions on that issue, I'd like to spend just a couple of minutes on the deadline issue. First of all, we don't think, our argument, and we would submit to the court, that issue is not before the court properly. It was not an issue that was raised in the trial court. It was not an issue that was assigned as an assignment of error in the 14th Court of Appeals, right? And so we know by Texas Rules of Appellate Procedure, I think 52, says that you have to present these types of issues to the appeals court before they are properly before the Supreme Court. And so we would argue that that specific deadline issue is not properly before the court and it shouldn't be considered. But even if the court were to consider it, I think it tracks back to what has this court tasked the lower courts to do. And I don't think that we'd ever find an opinion of this court that has said, you have to analyze, you have to beat the 120-day statute to determine whether the true nature of this case is a healthcare liability claim or not. I couldn't find any case where this court has said that is a requirement. So I think that even at the point of after the filing of a dismissal motion, we have the right under the law to do exactly what we did. Ask the court to determine whether we even needed to submit an expert report. And I think that's what these courts have done.
You agree, though, that if your amended petition states a healthcare liability claim, it has to be dismissed because it sort of relates back to the deadlines that applied to the original case, the 120 days?
I think if the nature of the claim is a healthcare liability claim, anywhere in the process, it would be dismissed at the 120-day stage.
So you're not saying you get another 120 days or that there's some other deadline?
No, Your Honor, absolutely not. I think the courts have been pretty clear about that 120-day deadline is a hard deadline in instances where you really are dealing with a healthcare liability claim. It can't be extended. It can't be amended around. And, I submit to the court that is not what we were attempting to do. In our amended, to show you the confusion when drafting, in our amended, second amended petition, we referenced dermatological care standards because we thought the skin is dermis, right? That's not what it is. We found out later it is cosmetological standards of care, which are non-medical by virtue of Texas law. The Texas Department of Licensing and Regulation has said that. But I think that is the reason there is a frequently asked question on that webpage, because these issues are so close that it's hard to determine where the medical ends.
So to be clear, you're not saying that after they filed a motion to dismiss, you amended to state a completely different claim like the slip and fall we were talking about. You're saying you amended to clarify what was the true nature of your claim all along.
Correct, Your Honor.
So, and that's why, to answer, to refer back to Justice Blacklock's question, if we agreed with the petitioner that the true nature of your claim all along was a healthcare liability claim, then the original 120-day deadline would apply.
That's correct, Your Honor.
The amendment wouldn't give you a new one.
That's correct. And that has never been our argument, right? Our argument all along has been that this was not a healthcare liability claim. And so I think, even in terms of how the 14th Court of Appeals phrased its opinion, they looked at it as whether or not my client had sufficiently rebutted the rebuttable assumption that when you sue a medical provider, it is a healthcare liability claim, right? And they've analyzed it solely on the issue of whether or not the absence of a patient-doctor-physician relationship rebut that assumption. And in their opinion, it did. I think that was the correct result. And you know, when I started, I said they didn't reach the medical issue, but I think they could have and reached the same result for the reasons that we've all talked about right now. I don't want to run past time, but I thank you all for examining this issue closely. I think it is a issue that needs to be examined correctly and issue that needs to be discussed specifically in the context of medical spas, because it's not a one-on-one relationship between a medical spa equals their practice in medicine. There are other things that happen there that are not healthcare related. And in particular, I think in this instance, if you were to overrule the 14th Court of Appeals, I think you would actually be materially altering the instructions that you have given to courts on this issue in your prior opinions. Because I think this really is a fact-based analysis that followed down the line your prior instructions on how to handle these types of claims, and the courts did exactly what you told them to do.
Any other questions? Thank you, Mr. Armstrong. Ms. Vickner, I believe you have 5 minutes.
Thank you, Your Honor. In listening to opposing counsel's argument, I kept getting the sense that this sounded like just classic Diversicare recast. It also struck me that much of what he discussed with the court this morning is nowhere in the record. He's the plaintiff. He had to rebut the presumption. He presented nothing in this record that had anything to do with what Ms. Gutzman was and wasn't allowed to do, what were these procedures that he said were performed on his client. Because healthcare providers were sued, and they were sued for allegedly providing negligent treatment to this patient, then it was up to him to show this court that those treatments were not medical treatments or healthcare treatments, to Justice Busby's point. The Texas Medical Liability Act, in all its incantations, has been around for a long time. This court has written on it so many times. The courts of appeals have written on it so many times. Claimants are sort of at their peril when they're filing their petitions in courts, alleging claims against doctors and their affiliates and their employees, alleging treatments were performed on them that injured them. The presumption applies. This court has noted in multiple of its decisions, the expert report requirement is triggered when a plaintiff names a person or entity as a defendant and seeks to obtain relief from them based on facts that possibly implicate the TMLA. That's Lois Sega. This court...
the various concessions that have been made this morning, how about if we just assume good faith on everybody's part that we're trying to get to the true nature of these claims and look at the live petition to decide if this is a healthcare liability claim or not, rather than getting into whether it's recasting or not.
And Your Honor, to your point, then let's take that petition, let's juxtapose it with the Texas Medical Liability Act, and then let's run through the definitions and run through the rubric. So we know Dr. Yarish is a physician, check. His facility is affiliated, check. And Gutzman is the employee, check. So now we've all got healthcare providers. She is clearly alleging treatment, and on top of that, alleging abrasive dermatological treatment in her second amended petition.
And what do you say in response to counsel's point that the TDLR doesn't consider that medical treatment and it needs to be medical treatment?
If she alleges, not only in her petition, but she says in her affidavit that they performed microneedling on her, phototherapy, microdermabrasion, which again, as I've stated, is supposed to be surgical. My position would be the label that's been placed on her does not necessarily capture what exactly she was and what exactly her job entailed. If it was purely cosmetological, then why did a doctor need to supervise? Plaintiff has alleged that the doctor failed to supervise these treatments as he should have, and she was injured as a result. We say that, again, cosmetology does not appear to truly be the issue in this case based upon plaintiff's own affidavit and what she says was performed upon her. And as we've talked about, an expert is going to be required to determine whether Dr. Yarish properly supervised his patient, his employee, when she performed these various treatments on this patient. A layperson in their common knowledge does not know what the dermatological standards are, does not know what IV peel is, does not know what microdermabrasion is, VI skin pen, and all these other phototherapies and all these things. A medical expert is going to be required, or a healthcare expert. There are two different provisions in the TMLA. One is qualifications for a medical expert, one is qualifications for a healthcare expert, so we know they're two different things. And we say that if you look at this petition, you juxtapose it with the act, we know a presumption is supposed to apply. This court has stated on multiple times, we look first to the pleadings. You said that in Loaisiga. Justice Bland said that in the Coming Attractions case, that the pleadings bore out the fact that her claims were healthcare liability claims. And as this court has said, filing an expert report is a low threshold for a plaintiff who brings a claim against a healthcare provider alleging that treatment caused their injury. So to the point that was made earlier about why not just go ahead and get an expert report on file, this court has considered that in other contexts as well. It is a low threshold for the plaintiff. If it's borne out later, it's not a healthcare liability claim, so be it, but they've escaped the deadline that's mandatory under the statute.
Do you agree that some estheticians do not provide services that are not healthcare and are not healthcare providers?
Do some estheticians provide, yes.
Provide services that are not healthcare?
I think I have to. I guess estheticians can do a number of different things, many of which are not medical care or health care. I suppose if Ms. Gaitan was alleging maybe that she had gone in and had her eyebrows waxed or something, maybe that would be different, although I don't know. It would depend on what the injury was that was complained about. But again, it was a presumption applied to the pleading that the plaintiff had to rebut, and she did not provide this court with anything in this record to suggest that what she was alleging was performed on her was not health care. So for all of these reasons, we would submit to the court that the 14th Court of Appeals opinion should be reversed. We believe that they actually applied standards backwards, applied some of the guiding rules and principles backwards, and we actually think that they have rewritten medical liability litigation as we know it. And so we're asking for a remand so that we can have these claims dismissed and have our attorney's fees and costs awarded to us. And I will give a little, I'm over. My apologies. Are there any other questions of the court?
Any other questions? Thank you, Ms. Vickman.
Thank you very much. Have a good day.
The case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.